All right, so that ends testimony for the day in this trial. Now, such a critical piece of evidence, and the judge was siding with the state on this. Let's bring in our criminal defense attorney that's watching along with us, Josh Ritter. Josh, your reaction to what we just witnessed there?
Well, now hearing the judge, it makes a little more sense as to what was taking place in court there. It sounds like the defense was actually making an objection under their state law to say that if there is evidence of tampering, you need to throw out that evidence altogether, and that's what they were asking for. Now, that begs the question, why are they making this motion now when it sounds like they would have known about this, alleged missing evidence from these envelopes, which, listen, the judge says it's no evidence of tampering. Okay, I'm going to respect that ruling, but to me that it's at least fishy. Why are there empty folds, as they're referring to them as, or evidence envelopes? It suggests that something was collected and it just didn't make it all the way to the lab where they were finally tested. So you would think if the defense knew about all of this ahead of time, they would have lodged, I would have lodged a 45-page treatise objecting to this evidence coming in because of tampering and had this all hammered out ahead of time. But instead they're making this objection kind of on the fly, and they got it denied by the judge. Now, they preserved that for appeal, but that wasn't the goal.
Right, and that's exactly what you said, Julia Janae. You're licensed in Florida, I believe, right? Mm-hmm. So you made that point when we were talking off camera.
It seemed a bit strange, but this is clearly a very keen defense team. It struck me as interesting that they mentioned, or the attorney that's sitting there said that, didn't I advise him not to speak to you or not to talk about a certain thing? And so this indicates that these public defenders have been on this case since the very beginning. Sometimes it passes from one person to another when you're talking about since 2016 that this case has been on the docket. But another thing I noticed in some of the writings that this defendant has sent to the judge. I know, Josh, you mentioned he might not be the sharpest tool, but he definitely has a penchant for writing and for writing long letters to the court. And at one point, he was upset that there weren't enough witnesses to verify his traumatic brain injury. He said he was under extreme duress, memory loss, Ambien pharmaceuticals. And he says that there are people that can verify that he was on Ambien, which he says it consumed the evening of the incident. Now, I don't know if that's a confession or not, but it may be something that we see come up. But do you think it will come up in this phase or in a sentencing phase?
Well, like you said, is that a confession? Are you now saying that you may have been there? I mean, you kind of have to pick your defenses here. You can't go with both, I wasn't there and had nothing to do with it, and I don't know why my DNA was anywhere around there. But if I was there, I was also under the influence of duress and narcotics and everything else that were affecting my ability. I mean, you can many times offer alternative defenses, but not these types of alternative defenses that you were either there or not there. And so I think that might be where the rulings that are not allowing for these witnesses to come in are coming up, because it's irrelevant. If you were not there, then what is the relevance of your mental state at that time if you're saying you were nowhere near the location? Right. I mean, it might have some relevance if he's going to offer some sort of mental deficiency defense, but that's not what we're seeing here.